session will discuss about the conveyancing part of drafting. As we all studied in the last session, the drafting is of two types. One is pleading and the other one is conveyancing. So, in today's session, we'll learn basics of conveyancing, and in the upcoming session, we'll take up pleading. So, in today's topic, we'll discuss what is conveyancing, what are the instruments of conveyancing, what is contract drafting, agreement and deeds, and other documents. So, this is all about conveyancing that you need to know, and all the basics, what are the instruments, what are types of conveyancing, what are documents, all of this will be covered in today's session. So these are just some basics of conveyancing, and I also told you in the last session also what is the definition of conveyancing. So first thing that you need to understand about conveyancing is that it does not include court proceedings. So conveyancing is drafting of documents, contract that is a matter of agreement between the two or more parties. So more of a private document, private drafting that writes down the terms of agreements that are agreed between the two parties. So it does not include court proceedings, because court proceedings and pleading is a drafting which is done and presented before the court. And conveyancing refers to the document by which a property is transferred from one source to another. So if you understand very basic of drafting, it is of conveyancing, it is simply that it's a document that decides the right and liabilities. It decides the transfer of one property from another. It decides the agreement terms and agreements regarding any property between two or more parties. And by property, we do not only means the land property, the physical property, but it can also include other things such as shares. It can include refers to the terms of contract and agreement reduced in writing. So there are two people who are agreeing to something, and all whatever is agreed between them is reduced in writing, is written in a piece of paper, and is signed by them. That is conveyancing. Conveyancing, conveyancing is not a part of court, but conveyancing can form a part of court as evidence. So, for example, if there is a agreement, there is an agreement between two parties regarding the sale of property from one person to another. So, and if there is any dispute on that property, that document of agreement to sell and sale deed, which is a part of conveyancing, which is an instrument of conveyancing, can become a evidence in the court of law, and which is essential also because the dispute is all about the property, and it's important that the all the written documents, all the agreements or writings are produced before the court. Example of a conveyancing is sale deed. So when property is transferred from one person to another, there is a document called sale deed, which is signed and agreed between the parties. That is an example of conveyancing. And if it has to go to court, it will go to court as an evidence. Basic rules of conveyancing. These basic rules of conveyancing are important to follow because whatever document you are drafting, it should be very readable. It should be very visible to whoever is reading it, and it should not cause stress to the eyes of the reader, which is why there are some basic rules that you should use a Times New Roman font, because it's not so stylish, it's very simple, it's commonly used. So it's good to use New Times Roman in the documents of conveyancing. Font size should be kept between 12, 13 or 14, and line spacing should be 1.5. Now this is not a strict rule that you have to follow, but it is advisable to follow these things. And even if you are not following this specific thing, you should make sure that your document is very, very readable, and that is the whole purpose of following this rule. Times New Roman, font size 12 or 14, and line spacing 1.5. And in conveyancing, you should use a format and strict and same format for all of your drafting. Although there is no such strict and format for conveyancing, and it depends from document to document and instrument to instrument. But the main purpose is that there is some format how the party name is to be written, how it has to be written, that it should follow, and your format should be same in all of the documents and all of the conveyancing that you are doing, so that you do not follow the different pattern every time you're doing drafting and waste your time in selecting a new format and new font space, etc. So this is a rule to save your time, to simplify the reading, and to use the same format which uh, becomes a part of your drafting. um, when the conveyancing is done, it is generally a matter between two personal parties like you and me. But we never use the name, personal names, except for where the identification is required. We always use terms there such as lessor, lessee, transferor, transferee, and what all of this means we'll learn in the upcoming slides. So you should always use these terms like lessor. Lessor is the one who signs the lease deed. Lessee is the one in whose favor lease deed is being signed. Transferor is the one who transfers the property, and transferee is the one in whose favor the property is transferred. So this is the common terminology that is used in conveyancing, which you should also use. Okay, now this is some vocabulary that is used in conveyancing. Party one and party two. When it is an agreement between two parties, then you will use the term party one and party two. Party one has agreed to do this. Party one has agreed to do this. This contract is between party one and party two. Party one resides here. Party one has agreed to sell their property at the consideration of this amount. Party two is accepting the consideration of this amount and has agreed to purchase the property. So this is a common language that will be used in conveyancing. Now, easy way to remember is that in conveyancing there are two parties. One who is transferring from, it's if I am transferring my property, then I am the transferor, the seller, and the other will be the purchaser or the transferee in whose favor the property is being transferred. So, the one who transfers, the words generally end in er or or, like the seller. Seller is the one who transfers the property. Buyer is the one who's purchased the property. Vendor is again another word for seller, is who selling the property. Vendi is the one who's purchasing the property. Transferor is the one who's transferring any of the rights, any of the property, any of the shares or anything, is the one which will be called transferor. Transferee is the one in whose favor it will be transferred. So if I am transferring a property in your favor, I'll be the transferor and you will be the transferee. Same with lessor. Lessor is the one who's leasing their property, and lessee is the one who's taking the lease, who's taking the property on lease. Promisor is the one who is promising to do anything, and promisee is the person with whom they're promising. So if I am promising to pay you 1,000 rupees, I will be the promisor, and if you accept and take that promise, and I am making that promise to you, you are the promisee. Releaser and releasee. Releaser is the one who release their right or who relinquish their right. Release is the one in whose favor this is the property or the right is released. So can any one of you tell me where do we see these words releaser and releasee generally? What is the document in which you'll find the
Ma'am,
term?
power of autonomy can also in conveyancing, no?
Yes. What?
Power of autonomy.
Power of attorney. Correct. It's a part of conveyancing.
Okay.
Hmm. So releaser is the term that is generally you'll see in relinquishment deed. Relinquishment deed is also a part of conveyancing, and relinquishment deed is a document by which someone relinquish their right in favor of anyone, which is generally seen in family property issues. There is a family person who don't want ownership or their share in the property. So a lot of times people release or relinquish their right in favor of the other person. For example, the let's say the brother is moving to a foreign country and he doesn't want the ownership of the property. He will file, or he will sign a relinquishment deed in which he will be the releaser. which means he's releasing his share in the property in favor of other family members. And the other family members in whose favor he's releasing the right, they'll be called releasee. Yes, and this document is called relinquishment deed. Is it clear so far?
Ma'am, is it also called as release date?
Release deed, yeah, it can be called release deed as well.
Okay.
Okay. Now, there are some instruments of conveyancing, although anything that is agreed between two parties, it can be reduced into a writing. It can be on simple paper, it can be on a blank paper, it can be on stamp paper, it can be on the notarized paper. So the instruments of conveyancing are very, very wide. Here are some of the examples that that I'll try to tell you, and some these are just simply the examples and some of the documents of conveyancing. So first, we will look at contracts. So there are different types of contracts, and a contract is simply an agreement between the two parties reduced in writing on a simple paper. And on contracts, there is not a lot of legal procedure, or the legal requirements are required, like the requirement of paying the stamp duty, or buying the or getting it notarized, or buying the stamp paper, etc. All of this is generally not required in contracts. So, what is an employment contract? Employment contract is a contract that you will see when people go and take their job, and the company, whatever the offerings are on behalf of the company and agreed between the employee. So, that is the agreement between employer and employee. That is called employment contract. In employment contract, you will generally see um, different types clauses, such as clause regarding salary and remuneration, work timings, regarding your holidays, leaves, regarding how you should serve the notice period, how long should be the notice period, jurisdiction clause, etc. So all of these terms, when are agreed between the two parties, which are employer, that is the company, and the employee, the one who's seeking the job, that is employment contract. Commercial contract is contract between two parties, two companies, two people who have agreed to come together and are doing any commercial activity together. That is a commercial contract. So if two people have come together to construct a building, some of the responsibilities will be of party one, some of the responsibilities will of the party two, and together it will be called commercial contract. Work contract is a little different from employment contract, because work contract can also be like a contract for freelancing, and it can be a contract for specific work, like if you are hiring someone to let's say an architect to design the house for you. Then in that case, an agreement contract can be signed, agreed between you and the architect. That can be called a work contract. Loan agreement is the one that is the bank drafts and offers it to the one who's taking the loan. So loan agreement will be a document of terms and agreements that is agreed between two parties, that is bank who's giving the loan and the person who's taking the loan. Now, promissory note is generally, or some, it can be a unilateral contract, meaning it can come simply from one party. Obviously, it will have the details of the other party as well. But even if I write on a piece of paper that I promise to pay 1,000 rupees to you, that is a promissory note. It can be on the affidavit also. It can be on simple piece of paper also. And there are other type of contracts that are called unilateral contract, bilateral contract, tripartite contract. Unilateral contract is the one in which I am the only one who's making some unilateral promises, meaning I am the one who's saying I'll do this, but there's not an agreement or a promise from the other party. That is called unilateral contract, one which is signed by one person only. Bilateral contract is like any other contract, or so you can also call. Generally, all the contracts are called bilateral because they are agreement between the two parties. Tripartite agreement is the agreement between three parties. So three parties are involved in a tripartite agreement. Can anyone give me an example of tripartite agreement, or where you generally see tripartite agreements?
Can it
Loan
be
agreement.
between the landlord, broker, and the tenant.
Loan agreements.
Loan agreement. Okay, someone said loan agreement. What you were saying will be generally there will be broker and house. There is that's generally an agreement between the tenant and the landlord. If there has to be a contract, it will be a separate contract between broker and the landlord, and the broker and the buyer or the tenant. Tripartite agreement, the best example of tripartite agreement is like loan agreement, and is what you will generally see in the construction of builders, the kind of construction that builder does. So what happens is, and you will see a lot of cases in court also regarding this kind of tripartite agreement. There is a builder who wants to build a society. So the builder will get a piece of land, and then uh, even before starting, the construction, what the builder can do, they will go to the buyers, the interested home buyers who are interested in buying a flat in that society. But since there is no flat as such, and it will be constructed, and it will be the possession will be given after a point of time. So and house owners also wants to take a loan from the banks, because they don't have the means to pay all of the money at once. So what happens is there is an agreement between bank, the builder, and the home buyers. Bank will give transfer the money to the builders directly, but the loan will be in the name of the home buyer. So the home buyer will approach the bank, and it has to be particular bank. So the builder has also agreed before that you can take banks from HDFC Bank, Axis Bank, and the banks are also specified. So as a home buyer, you're going to a bank, and you'll go to the bank and you will take the loan. The loan will be in your name, and it will be written in that agreement only that possession will be given to you after this much of time, 3 years or 4 years. And during this time, some of the times agreement is that EMI will start after you get the possession, and some of the times EMI starts the moment you sign the agreement. The one time payment will be made from bank to the builders, so that builders have the money to construct the society, and home buyers will keep on paying the bank in equal installment in EMIs, and ultimately they'll get the possession and the ownership after some point of time. So this is a tripartite agreement in which money never comes to the home buyers; it directly goes to the builder. It solves the problem of the builder, that of the investment. Home buyers also do not have to pay at once, and home buyers also do not have to uh, uh, you sometimes don't have to pay till they get the possession of the flat. And banks provide their services, because that is what they do. Banks provide loan for different purposes. Now, in such tripartite agreement, in courts you'll see dispute arises when the possession is not given to the home buyer. So they say, why should we keep on paying the EMI when we are not getting the home? Sometimes builders run away, they don't complete the construction, and there has been a lot of scams like this. So home buyers refuse to pay money because they'll not get the possession of the flat. And in such situation, bank pushes the home buyers, because the agreement is on the name of home buyer, of a private person. So these kind of disputes arise. So court has to come in between to decide how this dispute has to be decided. This is an example of tripartite agreement. Is it clear?
Yes, ma'am.
Any questions so far?
No.
No. Okay. So I'll continue with the other second type of instruments of conveyancing. That is deeds and agreements. Deeds and agreements are more or less the same thing. First, agreements come in place, and then deed come in place. So if you are going to draft a sale deed, you will have to draft an agreement to sell first. If you're drafting a lease deed first, then you'll have to draft an agreement to lease first. So agreement to lease is the first document in which all the terms and agreements are just written, and it is written that after 1 year of time or after 6 months of time, the sale deed will actually take place. So generally, agreement to sale is the first document that contains all the agreements, terms and conditions between the two parties. When they agree to it, when there is no dispute, which is agreement to sell is also done at the time of earnest money जो देते हैं, वो जो token amount देते हैं, At that time, agreement to sell is signed. Once that is completed, all the formalities are completed, then the next document, that is the sale deed or the lease deed, then it is signed, and the main transaction, that is transfer of property, only takes place when the sale deed is signed. So agreement to sell also do not means that if two parties have signed an agreement to sell, that doesn't mean that the property has transferred from one person to another. The property and the ownership will be transferred from one person to another only when the lease deed or sale deed is signed between the two parties. So, agreement to sell and agreement to lease is only a primary document, not the final document for the transfer of property from one person to another. Rent agreement, like you asked, a rent agreement is on terms and conditions agreed between the landlord and tenant. Simple piece of document in which how long will the tenancy last, what is the rent, what are the services that are provided on behalf of the landlord, and what are the duties that tenant will have to take care of, what you have to do when you leave the house, notice period, kitne time ka serve karna padega. All of the things are reduced in writing in a rent agreement. Gift deed is a document by which property is or anything is transferred from one person to another by way of gift. That I have decided to gift my property, this property to this person as a gift. And in gift deed, it is also important. And if you're making notes, you should also make note of this. There is a consideration involved. We'll do it in detail and later, because in every contract, in every agreement, it is important that there is a consideration involved. When you are transferring something from one person to another by way of gift, it means I'm gifting. So it doesn't mean if when you're gifting something, the other person कुछ दे आपको. But contract भी नहीं हो सकता अगर कुछ consideration now, two-way equation now. So gift deed में generally the consideration that is considered is called love and affection. That I am transferring this property to this person out of my love and affection. And these two words are very, very important to write in gift deed. If you do not write this, then this question can arise that what is the consideration? And love and affection can be considered a consideration under gift deed. Sale deed, I've explained it to you. Sale deed is the first document, and agreement to sell is the other document that comes and which decides the transfer of property from one person to another. Partnership deed. Can anyone tell me when will a partnership deed will be signed?
When two partners come in a business.
Okay. Yeah, when two or more partners are coming in a business and they agree to do or carry out some business commercial activity on their own, then they will sign a partnership deed. Partnership deed will decide the roles of the parties, role of the partners.
And partnership deed can also be and buying in and property also. No, if suppose one property is there, there can be two
Joint
property owners, joint owners.
Yeah, partnership is generally is generally used for commercial, for business purposes only. What you're saying is it will be a joint ownership property. If we are transferring this, उसमें partnership deed नहीं होगी, उसमें sale deed ही होगी. Okay.
Okay, ma'am.
Okay.
But in the sale deed there will be two person mentioned, no? Like
yeah. You'll have to mention two-person details of two persons and what property is going to one person, what property is going to the other person. What partnership deed it can do is that partnership deed में ये mention हो सकता है कि we have acquired this property for the purpose of business, and this business is the ownership of it, and we have the equal share in this property. That can be a terms of agreement in partnership deed. कि कोई property acquire की है, और जो property acquire की है, it's a business property. In that case, that can be a clause in partnership deed. And will is a property, you must have known, it's a very common thing. Will is a document by which the person who's about to die or who's dying gives in writing that how do I want my properties to be treated in future, after I die, after my heirs, and kitni property किस heir को जाएगी, kitni property किस बच्चे को जाएगी. All of these things are written in will. And sometimes in will they also donate all their property, people donate also all their property. So person writing a will just writes, decide, gives an undertaking that these are my properties and I'm giving my properties, I'm leaving my properties to this person, and they can acquire the property after my death. So that is simply a will. Now, other documents that will form a part of conveyancing are MoA. MoA is Memorandum of Association. AoA is of Article of Association. Memorandum of Association, Article of Association are the documents that are filed, that are drafted when a company is formed. Memorandum of Association is, contains the name clause, registration clause, the company address, basic things of the company. And articles of association are also called the bylaws and of the company, मीनिंग कि जब एक कंपनी सेटअप होती है तो उसकी भी एक वर्किंग होगी, उसमें भी कुछ रूल्स और रेगुलेशंस होंगे. अगर वो एक आईटी कंपनी है तो उसमें अलग रूल्स और रेगुलेशंस होंगे, कंस्ट्रक्शन कंपनी है तो एक अलग रूल्स एंड रेगुलेशन होंगे, लॉ फर्म होगी तो अलग रूल्स एंड रेगुलेशंस होंगे. मतलब एक कंपनी जो भी होती है उसको भी चलाने का एक तरीका होता है, उसके भी रूल्स होते हैं. All of that rules when reduced and writing are called service rules, are which form a part of articles of association, which is like a constitution of any company, which is why they're called bylaws. Terms and conditions, if you will see, whenever you're downloading an app, whenever you're visiting a website, even when you're purchasing a product, there is a certain terms of conditions that you agree to, and that is also called a contract. Even though there is, you do not sign on anything, but the moment you purchase something, moment you go and visit a website, you agree with terms and conditions of that service provider of that platform. If you are visiting Amazon, there are some terms and conditions of Amazon that you'll require to accept, which you have to accept. If you do not, put that tick on that terms and condition, you will not be able to use Amazon app. You will not be able to use WhatsApp. So it means that you agreeing to a terms and conditions, that means you and Amazon are agreeing and entering into a contract, whether you read it or not. But whatever is written in those conditions, you are agreeing to it. That means that. So that is also a contract, terms and condition. That also forms a part of conveyancing. And with so much of digitalization, all of these things have become very prevalent, and the drafting of these things are required, by a lot of companies, by a lot of websites. So this is another thing that you can involve and you can draft and can get paid for it. Okay. Can anyone of all of you, those who are present here, can give me an examples of other instrument of conveyancing?
Ma'am, a license of can be a part of conveyancing.
What?
MOU.
License of something can be a part of conveyancing.
License, you mean the license that government gives?
Yes, ma'am, of doing a business or something.
Okay, so ये generally the certificate कहलाते हैं, because whenever you get a license or anything, it's a prescribed form that government does. And now from government perspective, from government point of view, किसी ना किसी ने तो वो draft किए होंगे license की language. अब वो fixed हो चुकी है, वो change नहीं होगी. So that is simply a certificate that you get from the company or from the government. For government, it can be called as conveyancing a draft because it involves drafting. But generally, we use the term license or certificate of forms for these things. Okay. So your voice is not clear. Can you repeat it?
Memorandum of understanding, is it a part of conveyance?
Yes, completely. Memorandum of understanding is more or like MoA and MoU. Memorandum of understanding is a contract only in which two people come to an understanding regarding anything. So that is called memorandum of understanding, and it is part of conveyancing, and it's a good example of conveyancing. Okay. Someone has asked the question, the difference between deed and agreement. Can anyone try to explain the difference between deed and agreement? This question is by Prerna Ghate. I'll explain it after this. Anyone can explain the difference between agreement and deed?
Ma'am, when it is deed, that deed means that transferring the property or transferring the right of something to another person. And when it is the agreement is just for some time, ma'am. It is not permanent.
Yes, correct.
Like.
ठीक है, जस्ट टू ऐड इट टू इट, मैं एग्जाम्पल की तरीके से समझा रही हूँ सो दैट इट बिकम्स अ लिटिल ईजी कि आपको प्रॉपर्टी लेनी है, आप प्रॉपर्टी डीलर के पास गए या फिर आप अपने कोई यू आर बाइंग द प्रॉपर्टी फ्रॉम रिलेटिव ऑफ योर्स, तो आप और आपके रिलेटिव साथ बैठे और हमने कहा कि अच्छा ठीक है ये प्रॉपर्टी है, आप ये 50 लाख में आज ये प्रॉपर्टी खरीदने का अग्रीमेंट करते हैं, क्योंकि प्रॉपर्टी खरीदना या फिर ट्रांसफर ऑफ ओनरशिप इज अ लॉन्ग प्रोसेस। तो आप पहले रिलेटिव के पास गए, आपने कुछ अपने डिसाइड किया कि अच्छा ये प्रॉपर्टी है, ये यहाँ पे सिचुएटेड है, दिल्ली में है, दिल्ली के इस एरिया में है, 50 लाख में आपको 50 लाख में आपने खरीदने को अग्री किया, 50 लाख में उन्होंने बेचने को अग्री किया। अब ये जो लिखा जाएगा ये अग्रीमेंट टू सेल होगा। पहला जो डॉक्यूमेंट साइन होता है, तो आप ऐसे समझिए कि जब प्रॉपर्टी ट्रांसफर होती है तो 2 चीजें साइन होंगी, अग्रीमेंट टू सेल एंड देन सेल डीड। पहले में आप सिर्फ डिसाइड करोगे कि अच्छा ये प्रॉपर्टी है, इतना अमाउंट है, इतना कंसिडरेशन है, अब ये आप 6 महीने बाद आप इनको 50 लाख रुपए दे दोगे या 50 लाख रुपए देना स्टार्ट करोगे, या फिर कुछ और भी अग्रीमेंट हो, कुछ भी हो सकता है जो भी लिखा हुआ हो कि अभी कंस्ट्रक्शन चल रही है इसलिए 6 महीने बाद से स्टार्ट होगा। तो एक पहला स्टेप होता है, पॉइंट नंबर 1 होता है कि आप जो भी चीज अग्री कर रहे हो, जो भी आपके बीच की बात है कि हमने प्रॉपर्टी लेनी है, प्रॉपर्टी बेचनी है, उसके लिए पहला जो अग्रीमेंट कॉन्ट्रैक्ट साइन होता है वो अग्रीमेंट टू सेल कहलाता है। वो भी सेम स्टैम्प पेपर पे होगा, उस पर भी नोटरी होगी, वो सेल हो गया, वो हो गया, अग्री कर लिया। बट अग्रीमेंट टू सेल डजंट मीन कि वो प्रॉपर्टी आज ट्रांसफर हो गई है, क्योंकि प्रॉपर्टी तो तब ट्रांसफर होगी जब पेपर आपके फेवर में साइन हो जाएंगे, जब आपकी ओनरशिप आपके नाम लिख दी जाएगी। वो जो ओनरशिप का ट्रांसफर होता है वो सेल डीड में होता है। तो जो अग्रीमेंट टू सेल की डेफिनेशन होती है या फिर लैंग्वेज होती है वो ये होती है, आई अग्री टू सेल माई प्रॉपर्टी टू party 2 or to the transferee on this date, that is after 3 months of this from today, and the transferee has agreed to pay me 50 lakh rupees on this day, that is 3 months from today। कि मतलब हमने अग्री किया कि आज से 3 महीने, मैं सिर्फ प्रॉमिस कर रही हूँ काइंड ऑफ कि आज से 3 महीने बाद मैं अपनी प्रॉपर्टी तुम्हें ट्रांसफर कर दूंगी, दैट इज अग्रीमेंट टू सेल। जिस दिन मैं प्रॉपर्टी ट्रांसफर करूंगी दैट इज आफ्टर 3 मंथ्स, और जिस दिन तुम मुझे 50 लाख रुपए दे दोगी उस दिन मैं ये राइटिंग साइन करूंगी कि दैट आई हैव ट्रांसफर्ड माय प्रॉपर्टी। सो बेसिक, इफ यू अंडरस्टैंड इंग्लिश की, अगर आप इंग्लिश लैंग्वेज के थ्रू इसको समझने की कोशिश करोगे तो बहुत ईजी है। एक डॉक्यूमेंट में लिख रही हूँ कि आई एम प्रॉमिसिंग टू गिव ट्रांसफर माय प्रॉपर्टी टू यू इन फ्यूचर, एंड दूसरे में आई हैव ट्रांसफर्ड माय प्रॉपर्टी। या so dean will be confirmation of that transfer. Yes, okay.
Ma'am, this word transfer and transferee cannot be used in agreement, no?
डिपेंड करता है आपका अग्रीमेंट किस चीज को लेकर है। अग्रीमेंट जैसे आपने, अगर आप अग्री कुछ ऐसी चीज है कि आप सिर्फ ट्रांसफर ही उसमें रिक्वायर्ड है, तो आप ट्रांसफर और ट्रांसफर ही लिख सकते हो अग्रीमेंट में। अगर आप पूछ रहे हो ये सेल डीड के रिगार्डिंग, तो इसमें ट्रांसफर एंड ट्रांसफर यूज हो ही सकता है। सेल इज आल्सो अ काइंड ऑफ अग्रीमेंट, नो? इसमें तो हम ट्रांसफर एंड ट्रांसफर ही वर्ड यूज कर रहे हैं।
And ma'am, what is the difference between this lease deed and this agreement of rent?
लीज डीड, ओके, लीज डीड जनरली लंबे टाइम के लिए दिलवाई जाती है, उसमें ज्यादा राइट्स इन्वॉल्व होते हैं। लीज डीड इज लाइक गेटिंग द ओनरशिप ऑफ अ प्रॉपर्टी फॉर 10 years, फॉर 20 years। रेंट एग्रीमेंट क्या होता है, वो 1 साल के लिए होता है, फिर वो रिन्यू होता है। तो रेंट एग्रीमेंट इज ऑल्सो, द अदर डिफरेंस इज रेंट एग्रीमेंट वैसे तो कमर्शियल के लिए भी यूज हो सकता है, इट्स रिलेटेड टू एन ऑलरेडी बिल्ट प्रॉपर्टी, की एक शॉप हो गई, एक घर हो गया, उसके लिए रेंट एग्रीमेंट होगा। और लीज डीड जनरली कमर्शियल एक्टिविटीज के लिए ज्यादा वो की जाती है. वैसे तो एक और भी चीज एग्जांपल होता है, परपेचुअल लीज डीड होती है. और परपेचुअल लीज डीड होती है कि हम परपेचुअली आप सारे राइट आपके फेवर में ट्रांसफर कर दे रहे हैं. दोनों मोरलेस सेम ही है कि आप रेंट पे, एक तरीके से रेंट पे ही प्रॉपर्टी ले रहे हो, बट लीज डीड में राइट्स ज्यादा मिलते हैं, रेंट में कम राइट्स मिलते हैं. लीज डीड ज्यादा टाइम पीरियड के लिए होती है, रेंट एग्रीमेंट कम टाइम पीरियड के लिए होता है. दोनों रिन्यू हो सकते हैं. लीज डीड होगी 10 साल के लिए, 50 साल के लिए, 100 साल के लिए, या परपेचुअल के लिए 99 ईयर्स के लिए. रेंट एग्रीमेंट जनरली 1 साल के लिए होगा और वो रिन्यू होते रहेगा. और लीज डीड में एक सबसे बड़ी वो मिलता है दैट यू कैन ऑल्सो अग्री कि आप इसमें कंस्ट्रक्ट बिल, क्योंकि आप वो 10 साल के लिए है, तो उसमें ये भी राइट आपको मिल जाता है कि यू कैन गेट समथिंग कंस्ट्रक्टेड ऑन दैट प्रॉपर्टी. जब आप जाओगे तो आपको तोड़ के जाना पड़ेगा कि आपने लीज पे आपने एक प्रॉपर्टी, एक प्लॉट लिया है, खाली प्लॉट, आपने उसमें कुछ कंस्ट्रक्ट कर लिया क्योंकि आपने 10 साल के लिए लीज ली है, आपको कुछ काम करना है, अपना बिजनेस करना है, तो वो कंस्ट्रक्शन का राइट भी आपको मिल जाएगा, जो रेंट एग्रीमेंट में जनरली नहीं मिलता है. तो आपने अपनी जो भी कंस्ट्रक्शन करी, शॉप बिल्ड करी है, वो आप कर सकते हो, विच इज वेल विद इन योर राइट इन लीज डीड. जब आप जाओगे तो आपको तोड़ के जाना पड़ेगा. दैट इज मोर और लेस लीज डीड. ओके. कुछ कुछ असेंशियल इंफॉर्मेशन होती है सारी कन्वेंसिंग में दैट यू शुड टेक फ्रॉम योर क्लाइंट इमीडिएटली. नेम ऑफ द पार्टी, फादर्स का नेम उनसे पूछोगे कि वो किसके सन है, किसकी डॉटर है, और कहाँ रहते हैं, जिसके लिए यू कैन ऑल्सो टेक देयर आधार कार्ड. And this is important to identify the person that I am Simran Gill and मैं कोई प्रॉपर्टी ट्रांसफर कर रही हूँ, तो मेरी आइडेंटिफिकेशन श्योर होनी चाहिए, क्योंकि दे कैन बी अ लॉट ऑफ सिमरन गिल इन द होल वर्ल्ड. सो इट्स इम्पॉर्टेंट कि दिस इज द सिमरन गिल जिससे मेरी डील हुई है, मेरा अग्रीमेंट हुआ है. एंड हाउ डू यू आइडेंटिफाई दैट? If I write Simran Gill, there can be a lot of Simran Gill. So the other party can take the claim कि नहीं, ये वो Simran Gill नहीं है, और I can take that claim कि नहीं, I did not do this, I am not this Simran Gill. Which is why identification, it will be written Simran Gill, daughter of this. So उससे थोड़ी श्योरिटी हो जाएगी कि अच्छा सिमरन गिल है, इसके फादर का नाम ये है, कंफर्म हो गया, तो ये इंसान है, दिस इज द ओनली पर्सन हु हैज अग्रीड टू ट्रांसफर द प्रॉपर्टी. और श्योरिटी होनी है तो रेजिडेंस ऑफ, कि ये भी हो सकता है कि सिमरन गिल फादर नेम भी सेम है, ये भी पॉसिबिलिटी है. तो इसलिए ये बहुत कम पॉसिबिलिटी है कि सिमरन गिल, डॉटर ऑफ दिस पर्सन रिजाइडिंग इन दिल्ली एट दिस प्लेस, then it is sure कि okay, we are talking about this person only. So all of this information is very important to mention in all of the conveyancing that you are doing. And sometimes you can also mention the age of the person. But all of these things are very important, and you should always mention this in your conveyancing, whatever type of contract and agreements that you are writing and drafting. Details of the property, it's very important to define the property. कि मेरी प्रॉपर्टी है, उसका एड्रेस है D18, D17, कि वो किस एरिया में लोकेटेड है, कितना उसका एरिया है, कि वो 400 गज की प्रॉपर्टी है, 500 गज की प्रॉपर्टी है, उसके आसपास क्या है, और कितना एरिया पार्किंग के लिए होगा, कितना एरिया किस चीज के लिए होगा. सारी डिटेल्स जितनी प्रॉपर्टी को आइडेंटिफाई करने के लिए कि आप लिखनी इंपॉर्टेंट होती है. बिकॉज इस चीज पे भी डिस्प्यूट्स बनते हैं कि आपने ये अगर क्लैरिटी नहीं है कि एरिया कितने का है, तो आपने पैसे दिए हैं 500 गज के, उसमें लिखा ही नहीं है एरिया, उसमें 450 गज लिखा है कॉन्ट्रैक्ट में, या फिर 4 थोड़ा सा कम लिख दिया, इधर उधर हो गई, या फिर बाउंड्री डिमार्केशन में दिक्कत हो गई. तो ये सारी चीजें बहुत क्लैरिटी होनी चाहिए कि आप किस प्रॉपर्टी की बात कर रहे हो, और उस एरिया को जैसे मैथमेटिकली उसको डिफाइन करना होगा आपको. आइडेंटिफिकेशन ऑफ अ प्रॉपर्टी ऑल्सो कैन बी डन दैट दिस इज blue color house, red color house that I am agreeing to sell. I am agreeing to sell my red color car, blue color car जिसका नंबर ये है, इंडिगो है वो, या फिर मर्सिडीज है, कुछ भी. Date, time and place are all another essentials that you have to mention in contract agreements and everything. किस डेट को साइन हुआ, टाइम इज नॉट सो इम्पोर्टेंट बट यू कैन मेंशन इट, किस टाइम पे साइन हुआ है. एंड प्लेस, वेरी इंपॉर्टेंट, डेट एंड प्लेस, कि where it is signed, which tells where the person was present. And also important to mention the place, क्योंकि जो forged document होते हैं, तो अगर वो लिखा हुआ है कि दिल्ली में साइन हुआ है कि आई सिमरन गिल हैज अग्रीड टू सेल दिस प्रॉपर्टी एंड दिस अग्रीमेंट इज साइंड इन दिल्ली, मैं कहती हूँ मैं तो कभी दिल्ली गई नहीं, मैं तो प्रूव कर दिया था आई हैव नेवर बीन टू दिल्ली, तो फॉर्जरी बचाने के लिए भी दीज थिंग्स आर वेरी वेरी इंपॉर्टेंट. Consideration, again, very important thing. When I am agreeing to sell my car to you for 1 lakh rupees, you have agreed to buy that car for 1 lakh rupees. That 1 lakh, me taking that 1 lakh is consideration, you paying that 1 lakh is consideration. And consideration, and you must have studied in your law of contract, is a very important part of consideration. There can be no contract, no agreement, विच इज वाई आई ऑल्सो सेट कि गिफ्ट डीड में भी कंसिडरेशन होती है. आप कुछ दे नहीं रहे हो, मैंने किसी को कुछ गिफ्ट दिया है, मुझे उधर से कुछ नहीं मिलता, बट इन दैट केस ऑल्सो कंसिडरेशन इज कंसिडर्ड लव एंड अफेक्शन, क्योंकि ये भी एक तरीके का कॉन्ट्रैक्ट है. एंड कॉन्ट्रैक्ट में देयर कैन नेवर बी अ कॉन्ट्रैक्ट विदाउट अ वैलिड कंसिडरेशन, विदाउट अ वैलिड एंड लीगल कंसिडरेशन. कंसिडरेशन इलीगल भी नहीं हो सकती, ये भी नहीं हो सकता कि आई एम अग्रीइंग टू सेल यू माई प्रॉपर्टी, माई रेड कार, in exchange of drugs, that is also illegal, or in exchange of murdering someone, that is illegal. Witness, in lot of agreements, in lot of contracts, it's important at least sale deed में, relinquishment deed में witness होते हैं sign, दो witness on behalf of both the parties. There are two witness who signs, who are present at the time of signature. एंड रजिस्ट्रार ऑफिस में भी कभी कभी इनको प्रेजेंट होना पड़ सकता है. अब तो थोड़ा कम हो गया, दैट यू कैन जस्ट गेट इट साइन प्रेजेंटेड बिफोर द रजिस्ट्रार. विटनेस का पर्पस ये होता है कि वो भी कल अगर कोई डिस्प्यूट हो, अराइज हो, तो वो भी एक एविडेंस का फॉर्म पार्ट कर सकें. आई वाज देयर, इट वाज साइंड इन माय प्रेजेंस एंड देयर वाज नो कोअर्जन और नो अनड्यू इन्फ्लुएंस. जबरदस्ती नहीं करवाया ये साइन, अपनी मर्जी से किया, या फिर जबरदस्ती करवाया साइन, अपनी मर्जी से नहीं किया. इस चीज के लिए विटनेस इंपॉर्टेंट है. तो ये कुछ एसेंशियल इन्फॉर्मेशन हो गई जो हर कॉन्ट्रैक्ट में, हर अग्रीमेंट में, हर टाइप की कन्वेंसिंग में लिखनी पड़ेगी आपको. अगर हम जॉब की बात करेंगे तो वो जॉब का डिस्क्रिप्शन प्रॉपर्टी बन जाएगी, क्या जॉब है, किस तरीके का काम है, क्या करना होगा, सैलरी एक्सेट्रा एक्सेट्रा, ये बन जाएगा. सैलरी कंसिडरेशन बन जाएगी. एंड दिस हाउ टू वैलिडेट इंस्ट्रूमेंट. लाइक आई सेड कि कॉन्ट्रैक्ट तो तभी भी हो सकता है जब मैंने एक ब्लैंक पेपर पे कुछ लिख दिया. इफ इट इज अ ब्लैंक पेपर आई हैव साइंड एंड आई हैव प्रॉमिस्ड टू पे समथिंग, दैट can also be a valid thing, but does not hold so much of value in the court of law. What are the things that hold value in court of law which are not doubted? Affidavits. If you have given something on affidavit and you have get it notarized, then it has more value than something that is written on a plain paper and just simply signed. कॉन्ट्रैक्ट में एफिडेविट या फिर ये नोटरी की जरूरत नहीं होती है. कॉन्ट्रैक्ट जो साइन होते हैं, लेट्स से एम्प्लॉयमेंट कॉन्ट्रैक्ट, वो जनरली लीगल हेड, लेटर हेड पे होते हैं, जिसमें कंपनी का ऊपर नाम लिखा होता है. इफ यू मस्ट हैव सीन कि लेटर हेड पे भी बहुत इंपॉर्टेंट होते हैं कुछ डिक्लेरेशन देना या कभी कुछ नोटिस भेजना. ऑल ऑफ दीज आर डन ऑन लेटर हेड ऑफ द कंपनी, ऑफ द ऑर्गेनाइजेशन, of persons also. If you are an advocate, you also serve notice on your letterhead. So वो एक validating document हो जाता है. एफिडेविट हो जाता है जब हम नोटराइज करवा देते हैं ओथ कमिश्नर से. एंड ओथ कमिश्नर आर पीपल हु आर गिवन द लाइसेंस बाय गवर्नमेंट टू वैलिडेट दीज डॉक्यूमेंट्स, टू वैलिडेट इंस्ट्रूमेंट्स कि हमारे सामने हुआ, दोनों पार्टी प्रेजेंट थी, एक्सेट्रा एक्सेट्रा. सो वो एफिडेविट हो जाता है. स्टैम्प पेपर is a document that is used in non-judicial purposes. And if you will see also, stamp paper के ऊपर लिखा होता है for non-judicial purposes only. इसका मतलब ये है कि स्टैम्प पेपर जो आप साथ में लगा दे रहे हो, वो बात, वो आप काइंड ऑफ आप ओथ ले रहे हो. जैसे हम कोर्ट में जाते हैं तो हम ओथ लेते हैं एंड वी से whatever I'll say will be the truth and I will not tell any lie, whatever I'm telling is truth. तो कोर्ट में जैसे झूठ बोला नहीं जाता ना, वो गीता पे हाथ रख के कसम कहते हैं. स्टैम्प पेपर काइंड ऑफ एक सेम ही चीज होती है. आप ओथ ले रहे हो बट इट्स एन रिटन ओथ. You are, whatever you are saying the truth in presence of a government official, in presence on a government document. So इसलिए स्टैम्प पेपर जो आप स्टैम्प पेपर पे लिख देते हो वो सच हो जाता है बेसिकली इन कोर्ट ऑफ लॉ. So stamp paper, it's and stamp paper meaning it's you're paying 10 rupees का stamp paper, 10 rupees to the government, 10 rupees to the government to validate the contents of your document. And जब जनरल कॉन्ट्रैक्ट होता है तो सिग्नेचर से भी काम हो जाता है कि अब मैंने कुछ लिखा है, आपने कुछ लिखा है, हम दोनों के उस पर सिग्नेचर है या फिर थंब प्रिंट है, वेरी मच एक्सेप्टेबल इन कोर्ट. ओके
Ma'am, there are different amount of stamp papers. So what are the importance of different amount of stamp papers like 10 rupees, 50 rupees, 100 rupees?
सबके लिए एक्चुअली डिफाइन होता है. अगर मैं रेंट एग्रीमेंट बनाने जा रही हूँ उसके लिए 100 रुपए का लगेगा. अगर मैंने उसमें 10 रुपए का लगा दिया मतलब वो वैलिड पेपर नहीं है. तो मतलब जो भी अग्रीमेंट आप करते हो, और इसीलिए पढ़ना भी जरूरी है. जैसे इन द अपकमिंग ड्राफ्टिंग आई टेल यू दिस आल्सो कि जो भी आप अग्रीमेंट साइन कर रहे हो, जो भी आप ड्राफ्ट कर रहे हो, आपको उसको बेसिक लॉ पता होना चाहिए. और बेसिक लॉ पता करने का ऐसे लॉ और आपकी ड्यूटी यही है. उसमें 100 रुपए का स्टैम्प पेपर लगेगा, 500 का लगेगा, कितने का लगेगा, 1000 का लगेगा. वो हर डॉक्यूमेंट अलग होता है. अगर मैं मुझे सिर्फ एनओसी चाहिए, नॉन ऑब्जेक्शन सर्टिफिकेट, तो 10 रुपए का स्टैम्प पेपर पे लग जाएगा, वो 10 रुपए पे चल जाएगा. अगर आप कम का स्टैम्प पेपर चाहिए, आपने ज्यादा का लगा दिया तो कोई इशू नहीं है. लेकिन अगर आपको ज्यादा का स्टैम्प पेपर चाहिए, कम का लगा दिया, इसका मतलब वो वैलिडली एक्सेप्टेबल डॉक्यूमेंट नहीं है. तो स्टैम्प पेपर की इंपॉर्टेंस जनरली ऑन द वैल्यू ऑफ कॉन्ट्रैक्ट डिपेंड करती है. किस चीज का कॉन्ट्रैक्ट है, तो प्रॉपर्टी ट्रांसफर वाले में ज्यादा स्टैम्प पेपर लगता है, ज्यादा स्टैम्प ड्यूटी जाती है. और वो जब प्रॉपर्टी ट्रांसफर होती है तो स्टैम्प ड्यूटी एंड रजिस्ट्रेशन फीस आल्सो डिपेंड्स ऑन द अमाउंट ऑफ कंसिडरेशन यू आर पेइंग, बिकॉज इट्स लाइक अ टैक्स. आपको टैक्स करने की कोशिश हो रही है, मतलब जो ये ट्रांजैक्शन है इसमें कुछ टैक्स जाएगा गवर्नमेंट को. दिस इज अ वे ऑफ टेकिंग टैक्स which depends on the amount of consideration that is involved in this agreement and the type of agreement that it is. So वो लिखा होता है कहीं ना कहीं, वो आपको पढ़ के पता चल जाएगा. और ये जरूरी भी होता है देखना कि आप जब कौन सा स्टैम्प पेपर कितने अमाउंट का लगेगा. ओके
Yes, ma'am. Thank you.
Okay. Next thing, contract drafting. We'll start with contract drafting now, which is very basic and the easiest thing to draft. और कैसे करना है कॉन्ट्रैक्ट ड्राफ्टिंग, वो क्या क्या स्टेप्स लेने चाहिए, दिस इज व्हाट विल लर्न टुडे. सो कॉन्ट्रैक्ट ड्राफ्टिंग इज किसी भी कुछ भी लेके कॉन्ट्रैक्ट ड्राफ्ट हो सकता है. आप मेरे पास आए हो एज यू आर द क्लाइंट, आई एम द एडवोकेट. आपकी डिमांड कुछ भी हो सकती है कि आज मैं it can be related to transfer of property. It can be related कि I have मुझे कॉन्ट्रैक्ट ड्राफ्ट करवाना है बिकॉज आई एम गोइंग टू हायर एन आर्टिस्ट जिससे मैं अपनी सेल्फ पोर्ट्रेट बनवा रही हूँ, तो मुझे इसके लिए कॉन्ट्रैक्ट चाहिए. तो ये भी कॉन्ट्रैक्ट होगा. आप हमारे और मेरे बीच में मैंने आपको पढ़ाने का की ड्यूटी है, एंड योर ड्यूटी इज टू स्टडी, एंड इन एक्सचेंज ऑफ दैट यू हैव पेड अ कंसिडरेशन. तो ये सारे जो हमारे बीच में भी ट्रांजैक्शन हो रही है, अगर ये भी राइटिंग में होगा, ये भी कॉन्ट्रैक्ट हो जाएगा. बस कॉन्ट्रैक्ट क्या नहीं होगा, इफ यू आर कमिंग टू मी एंड यू आर सेइंग कि यार लेट्स डू समथिंग इलीगल, या फिर सुपारी दे दी किसी को मारने की, दैट इज नॉट अ वैलिड कॉन्ट्रैक्ट इन आइज ऑफ लॉ. Other than that, whatever is a legal thing that can be agreed between two parties, it can be literally anything in the world जहाँ लिखने को, जहाँ वो वैलिड है, लीगल है, वो कॉन्ट्रैक्ट का पार्ट हो सकता है. अब ये भी हो सकता है दो लोग कॉन्ट्रैक्ट का पार्ट कि मैं और तुम साथ में रहने का डिसाइड किया है एक घर में, इसलिए कि हम अपने फाइनेंसेस बांट सकें. आई डोंट नो यू, यू डोंट नो मी, बट वी आर लिविंग टुगेदर and we'll share the expenditure of this house, we'll share the rent of this house. ये भी एक तरीके का कॉन्ट्रैक्ट है. Now as a client you're coming to me कि I have to get this thing drafted and I want everything to be, terms and agreement to be written and signed. Everything should be in writing so that no dispute arises in the future, which is the main important task of contract. Contract लोग क्यों साइन करते हैं? ताकि हम लोग आपकी जो डिमांड्स हैं, आपकी जो नीड्स है, आपकी जो थॉट प्रोसेस है, मेरे डिमांड्स हैं, नीड्स हैं, थॉट प्रोसेस है, हम दोनों एक कुछ चीजें और जो ये किया था कॉन्ट्रैक्ट. तुमने बताया कि हम लोगों ने एग्री किया था ना दैट यू विल पे 50%, वो कहीं लिखा नहीं होगा के बीच में ये जो कॉन्ट्रैक्ट है क्या डिस्प्यूट्स आ सकते हैं and if you have already written written all the methods or the possible solutions or steps to be taken in that kind of dispute, that is what your job is. Be very clear about needs and demands of your client. जो आपके क्लाइंट की नीड्स हैं, डिमांड्स हैं, वो आपको पता होनी चाहिए कि व्हाट काइंड ऑफ contract they want, what is it that they want from the contract, what is that they want from the other party. ये आप जब इसीलिए काउंसलिंग सेशंस होते हैं क्लाइंट के साथ, लीगल काउंसलिंग होती है, सो दैट यू कैन अंडरस्टैंड कि अपने क्लाइंट को क्या नीड है, वो ये कॉन्ट्रैक्ट क्यों साइन करवाना चाह रहा है, क्यों कहाँ कहाँ पे ट्रस्ट इश्यूज हैं दोनों पार्टीज के बीच में। ये सारी चीजें जब आप समझोगे, देन ओनली यू विल बी एबल टू ड्राफ्ट अ वेरी वेल कॉन्ट्रैक्ट। स्टेट लेस वेयर योर इंटरेस्ट और क्लैरिटी इज लैकिंग। जितना इम्पोर्टेंट लिखना होता है उतना इम्पोर्टेंट लॉयर्स के लिए ना लिखना भी होता है। एंड लॉयर्स मेक दिस मिस्टेक ऑल द टाइम ऑफ राइटिंग टू मच, कि जहां उनको नहीं पता, जहां जहां आपको क्लैरिटी नहीं है, क्लैरिटी उस चीज को, लॉ को लेकर क्लैरिटी नहीं, देन इट इज अ प्रॉब्लम। उसको लेकर क्लैरिटी नहीं है, या फिर जहां आपके क्लाइंट नहीं पता, क्योंकि सब चीज फॉर्सी करना मुश्किल आसान नहीं हो पाता, नहीं पता, क्योंकि सब कुछ फॉर्सी करना मुश्किल आसान नहीं हो पाता, कर पाओगे कुछ कुछ ये प्रॉब्लम आ सकती है, प्रॉब्लम फॉर्सी कर पाओगे कि अच्छा ये जहां पे आप नहीं फॉर्सी कर पा रहे हो, या जहां पे आप नहीं फॉर्सी कर पा रहे हो, क्या प्रॉब्लम हो सकती है, मैं रेस्टोरेंट के लिए कॉन्ट्रैक्ट ड्राफ्ट के लिए, तो शेफ के लिए प्रॉब्लम आ सकती है, शेफ और रेस्टोरेंट के बीच, जहां पे आपको डाउट लग रहा है कुछ भी, जहां पे आपको क्लैरिटी नहीं मिल पा रही है और आप क्लाइंट से बात करने की क्लैरिटी नहीं हो पा रही है, वहां पे आप यू विल राइट लेस, यू विल use very vague terms, very open minded terms, so that later it can be used in your favor. बहुत ज्यादा लिख देना और promising too much, which is another mistake that lawyers make. Promising too much is also not a good thing to do in your drafting, because if you do not fulfill those promises, it will be a breach of contract and you will have to pay for it. So जहां पे आपको क्लैरिटी नहीं है, जहां पे आपकी इंटरेस्ट की चीज नहीं है, जो क्लॉज, जो राइटिंग आपकी इंटरेस्ट में नहीं जा रही है, वहां पे कम लिखें, एंड दैट्स वेरी इंपॉर्टेंट। एंड कोर्ट्स जनरली, मतलब बहुत बार ऐसा होता है, नॉट जस्ट इन राइटिंग, इन स्पीकिंग ऑल्सो, कि बहुत बार ना लॉयर्स को कुछ नहीं बोलना चाहिए, कोर्ट में जाके चुपचाप से खड़े हो जाना चाहिए, लेट द अदर पर्सन से। बट आदत होती है लोगों को बोलने की ऑल्सो, बिकॉज व्हेन पीपल आर गोइंग एंड स्टैंडिंग इन फ्रंट ऑफ कोर्ट्स, दे काइंड ऑफ एक्साइटेड टू से अ लॉट ऑफ थिंग्स, और इस चक्कर में बहुत बारी ना गलत सबमिशन हो जाते हैं, कुछ कुछ गलत चीजें सबमिट हो जाती हैं, so that should not happen. No one-sided and outrightly biased clauses. अगर आप कॉन्ट्रैक्ट में वन साइडेड क्लॉज है, एकदम ही पता चल रहा है कि दिस कॉन्ट्रैक्ट इज ओनली फेवरिंग वन पार्टी, देन इट कैन कॉज यू प्रॉब्लम इन फ्यूचर. So you should always escape from writing one-sided contract. That does not mean you will not write things that will favor your client, but you have to mold it and write it in such a way that it does not look outrightly biased है. मतलब देखने से पता चलता है कि आपका ही प्रॉफिट है, सामने वाले को लॉस लॉस है देख के. जैसे बहुत जगह भी ऐसा लिखा होता है ना कि if you know go for adventure sports, then you'll see this thing कि उसमें लिखा होता है कि we will not be responsible for any negligence. Even if we have negligence in our instruments or in our equipment, will not be responsible. You are giving your consent for any harm that will cause to you. तो ये जो कुछ कॉन्ट्रैक्ट है यहाँ जहाँ पे आपकी गलती होगी, आप ये नहीं हो सकता कि मेरी गलती पे कुछ नहीं हो सकता. You can't write all of these things because this will be challenged. You cannot simply write that if I am being negligent, even if I commit negligence, I cannot be I cannot be challenged or I cannot be questioned. वैसा अगर आपने ऐसी कुछ चीज लिखी है, then it will always be open to the other party to challenge that clause. तो यही होता है कॉन्ट्रैक्ट में. कॉन्ट्रैक्ट में जब डिस्प्यूट्स अराइज होते हैं तो पहले तो आप जो लिखा होता है उस पर फाइट कर रहे होते हो, पर जहाँ कुछ ऐसी बात होती है ना कि जो कॉन्ट्रैक्ट में क्लियर है कि आपको ये करना था, आपने नहीं किया, वहां पे आप क्लॉज भी चैलेंज कर सकते हैं. तो ये दो तरीके की चीजें होती है, इसलिए क्लॉजेस अगर आपने गलत लिखे हुए हैं that can be easily challenged, then if you have not done your job well as an advocate. So it's very important to do all of these things. Okay. So far, any questions? Please let me know.
Can you use maxims in contract like
Yeah. They can use maxims. Although it's not really advisable. I'll tell you why, because contract ऐसा होता नहीं है, and also because everyone has their own kind of practice, and whatever I am giving you is and it's really my advice, whatever I do. और जो मुझे सही लगता है, जो काफी लोग अभी जो चीजें करते होंगे वो तो I have no comments on, but contracts ना simple होने चाहिए. Because you are writing very different language in your contract, you are automatically creating prejudice to the other party. कि उनको ये चीजें समझना है। लीगल मैक्सिमम लॉयर्स को समझ में आते हैं, आपके जो क्लाइंट होंगे उनको भी समझ नहीं आएंगे। तो इस सबसे चीजें कॉम्प्लिकेटेड हो जाती हैं कि उनको नहीं समझ में आया ये क्या लिखा हुआ है। आप एक्सप्लेन कर दें तो भी अच्छी बात है, बट लैंग्वेज ऑफ द कॉन्ट्रैक्ट इफ इट इज फॉर बोथ द पीपल देन इट शुड बी सिंपल। जो जो डिफरेंट कॉन्ट्रैक्ट्स होते हैं ना, जो मतलब डिफिकल्ट जो गोल इज कि आप हाँ कॉन्ट्रैक्ट बिल करने में अपने क्लाइंट में भी बोल देगा कि कॉन्ट्रैक्ट साइन करने के सामने वाले को समझ ही नहीं कि वो किसका साइन कर रहे हैं, दैट इज अनदर थिंग, देन यू हैव टू डू लीगल मैक्सिम्स आप लिख के आप कॉम्प्लिकेटेड लैंग्वेज यूज कीजिए, बट otherwise try to keep contract as simple as possible, especially when you're writing for both the parties, जब दोनों parties आपके client है। be communicated to the other party. Now, because of this email, the communication has become very easy. You can simply email the contracts to the other party, and you can, just by way of WhatsApp messages पे भी चल जाते हैं अब तो. So all of these things have become very simplified communication. But ये सारी चीजें ingredients होने चाहिए. Consideration, which we have already discussed, it's very very important. Every contract you have to make sure there is consideration of some sort. चाहे वो ₹1 ही हो, चाहे ₹2 ही हो, चाहे वो love and affection ही क्यों ना हो. There has to be a consideration in every contract. Without a consideration, contract cannot be valid. Legal and valid terms. And legal and valid terms will just not mean like, कि illegal drugs नहीं sell कर सकते या फिर murder वाले terms. That's not something that I'm talking about when I say legal and valid terms. आप जिस चीज से भी रिलेटेड डॉक्यूमेंट बना रहे हैं, प्रॉपर्टी रिलेटेड, तो आप उसमें ये आपको पता होना चाहिए कि टर्म्स क्या क्या वैलिड हैं, क्या क्या लीगल हैं, क्या क्या चीज़ें अलाउड नहीं है लॉ के अंदर करना, क्या क्या चीज़ें अलाउड हैं करना. कि मैंने किसी को अपनी कार सेल कर रही हूँ और उसमें मैं ये अग्री कर रही हूँ कि उसकी नंबर प्लेट पिंक कलर की हो सकती है, विच इज़ नॉट अलाउड इन लॉ. So that's not a valid term, that I cannot, give consent to anyone to have pink color ki number plate because it's not allowed in law. As simple as that. I cannot sell my car to underage child because underage person because cannot own or cannot drive that car. So all of these things are important. What we mean by legal and valid terms are legal and valid terms of the field जिसका आप drafting कर रहे हो. Free will, if a contract is signed जबरदस्ती, under an undue influence, under fraud, under misrepresentation, under threat to one person or threat to your family members also, this will not be a contract that it can be challenged any time. मतलब वो कॉन्ट्रैक्ट तब तक रहेगा जब तक किसी ने चैलेंज नहीं किया, लेकिन वो कोई भी चैलेंज कर सकते हैं कि व्हेन आई वाज साइनिंग द कॉन्ट्रैक्ट दैट द अदर पर्सन, द अदर पार्टी हैड गन on my forehead, so I had to sign the contract. So that is not allowed. Free will होनी चाहिए दोनों parties की to agree into an agreement. And if you were talking about legal maxim, this is one legal maxim that is very common. Consensus ad idem, that we both are agreeing on the same thing in the same sense. I also want to buy a car, you also want to buy a car. I also want to buy a red car, you also want to sell a red car. I also want to buy for 50 lakh, you also want to sell for 60 lakh. तब हमारी फ्री विल है, हम सब चीज को लेके सेम पेज पर हैं. There is no misrepresentation, there is no threat, nothing, everything is done on free will. Terms of breach very very important, क्योंकि आप ये तो लिख देंगे अच्छा ये पार्टी की ड्यूटी ये है, बी पार्टी की ड्यूटी ये है, बट व्हाट विल हैपन इफ ए एंड बी डजंट फॉलो दैट ब्रीच. वो लिखना बहुत इंपॉर्टेंट है कि जब डिस्प्यूट हो वो easily smoothly sort हो सकें. That if one person is in breach of contract, that person will pay 10,000 to the other party. इतने सिंप्लीफाई होने चाहिए ब्रीच और वो सब डील करने का प्रोसीजर. बिकॉज इन टर्म्स जब ब्रीच होगी तो हैसल्स नहीं होनी चाहिए फॉर योर क्लाइंट. So which is why terms of breach, this will be called terms of breach, and what will happen if the breach is done. Jurisdiction and dispute clause. A jurisdiction and dispute clause is basically that clause which is also very very important in all of the contracts. If a dispute is arising out of this contract, how will it be dealt? Terms of breach is what is the breach. Jurisdiction and dispute clause basically decides कि कौन से कोर्ट में जाओगे आप. Basically कोर्ट डिसाइड करते हैं कहाँ के. That so in jurisdiction and dispute clause it is written that in case of any breach arising out of this contract, the competent all the disputes will be decided by the Arbitration and Conciliation Act by appointing an arbitrator, and the arbitration will take place in Delhi. और arbitrator कौन होगा ये भी आपने डिसाइड कर लिया. If arbitration fails, then the courts of Delhi has the jurisdiction to try the case. So wherever the contract is signed, generally that is a place where it is included in jurisdiction clause. and that's also called jurisdiction and dispute clause, to decide which court, कौन सा procedure लोगे, कि आप कौन से कोर्ट में जाओगे, कहाँ के कोर्ट में जाओगे, कौन से लॉ के अंडर जाओगे. This is what it defines. Okay. Okay. ABC company is engaged in business of construction. XYZ is an advocate who provides legal services in Delhi NCR. ABC company wants to engage XYZ advocate for their legal requirements. Draft an agreement between ABC company and XYZ. Okay, I just want to check how many people are there in the. Okay, there's some questions in the chat, so I'll take that first. First question is from Prerna. Format सबके लिए different होंगे. Generally देखने में सब same दिखते हैं सारे deeds. And अभी हम लोग देखेंगे कुछ, so it will be clear to you. Barred by law means they are not allowed by law to enter into a contract. Like what I gave you an example of Vijay Mallya. He's not allowed to do business in India. So he cannot enter into a contract of business with someone because that will not be allowed. Illegal, those who are in jail, they are barred by law. Those who are in prison, they are barred by law. That is called not allowed by law to enter into a contract or to do any business. Like अगर मेरा license cancel हो जाएगा या फिर I'm not allowed to teach, law ने मुझे बार कर दिया, then I cannot enter into a teaching contract with anyone. If I enter, that will be an illegal contract. Gayatri, yes. And Gayatri, you have a question?
No, ma'am. It was earlier I have raised the hand. It was not now.
Okay, it's still there. Okay, so then let's take this question. अभी इसको ड्राफ्ट करना है. I'll give you 5 or 7 minutes of time to think of some clauses. और क्लॉज क्या क्या होंगे ये. इससे पहले मैं आपकी उसके लिए एक employment contract, should I put it there? Although वैसे there are not a lot of people, so I think till जहाँ तक हमने last time किया था, we'll take it till here there only. So I'm giving you 5 minutes of time. What you have to do is think of what you are going to write. You are an advocate. You have to draft an employment contract. ABC company है. आप ही एडवोकेट हो who's going to work in an ABC company. कंपनी ने आपसे किया कि आप अपना कॉन्ट्रैक्ट खुद ही ड्राफ्ट कर लीजिए. तो अब नाउ यू आर गोइंग टू बी वर्किंग एज एन एडवोकेट फॉर ABC कंपनी. तो उसके लिए कॉन्ट्रैक्ट होगा बिटवीन ABC कंपनी एंड XYZ एडवोकेट. What is that thing that you're going to write in your agreement, in your employment contract? That is, we'll try to draft and just some clauses. And these are the hints of clauses. So I'm giving you 5 minutes of time. I'll just give one example: scope of work. So like the employee will be not employee, we'll use the term advocate. The advocate or the legal representative will be required to draft legal notices arising out of disputes on the day-to-day activities of the business of the ABC company. ये एक स्कोप ऑफ वर्क हो गया कि क्या काम करना होगा मुझे एज एन एडवोकेट ABC कंपनी में. लीगल नोटिस ड्राफ्ट करने होंगे. एंड देयर आर सम you have to think of more work so that we can just draft some clauses for your practice. Yes, Sandesh. Working hour. Okay. If you are not opening your mic, because I'll have to ask you to dictate. I'll type for you. So if you cannot speak, then you type your whole clauses in the chat. Let's start with
ABC and company is hiring an advocate for litigation work for day to day arising out of day to day.
एक second. Let's start. Let's start writing this. Can you see the screen? इससे पहले जो लाइन आएगी वो ये आ सकती है that
Ma'am, your screen is not visible.
Okay, okay. Presentation, एक second. I've shared something else. Okay.
Now it is visible.
Okay. So I have agreed to enter into account for availing the services of for availing the legal services of XYZ. ठीक है, ये हमने बस बेसिक ऐसी स्कोप ऑफ वर्क. गायत्री, वुड यू लाइक टू गो फर्स्ट? जैसे हमने लास्ट
companies hiring advocate XYZ to enter to file the litigation cases and look after the all legal matters arising in day to day
working of the company. Okay. I'll just rephrase a little bit. To what were you saying?
XYZ company is hiring advocate
No,
XYZ. Sorry, XYZ is required to look after the litigation work of company.
Work of the company. No, this is something very vague. Litigation work. तो हम इसको थोड़ा सा
And other than not limited to drafting notices and agreements.
Ma'am, first we have to begin with the personal details, right?
Yeah, but we are taking some clauses.
Okay.
स्कोप ऑफ वर्क के ऊपर हम बात कर रहे हैं. ये मैंने शॉर्ट में इसलिए थोड़ा सा ऐसे लिख दिया ABC एंड वो आप होगा, वो आपको मे बी फॉर्मेट्स आई विल शो इट टू यू, सो आई थिंक इट विल बी इजी टू जस्ट हैव अ लुक. फॉर नाउ आई एम वी आर जस्ट प्रैक्टिसिंग द ड्राफ्टिंग. So we are talking about specific clauses, but not limited to drafting notices, agreements, etc. Now, these of the company, these terms like arising out of day-to-day working and very important, not limited to. ये जो कुछ टर्म है बहुत इंपॉर्टेंट होते हैं ड्राफ्टिंग के, कि आप जब आप किसी का काम डिफाइन कर रहे हो and if you are drafting for the company, you can use terms like this but not limited to. Your work is to draft legal notice, but it's not limited to drafting legal notice. You might also be required to draft agreements and sale deeds, etc. ठीक है? Next. More. One more. और क्या एज एन एडवोकेट क्या और जॉब हो सकती है?
XYZ is required to look after the other branches or other franchisees in the other states of countries.
Is required to settle disputes and provide the legal assistance to other franchisee of the company located outside Mumbai, let's say. The cost of such legal assistance shall be paid on work basis as agreed between the parties at the time of ठीक है ये दिस इज कि एडवोकेट का काम ये भी हो सकता है कि लीगल असिस्टेंस प्रोवाइड करना लीगल असिस्टेंस एंड एडवाइस बट उस वो जब लीगल एडवाइस कहीं और प्रोवाइड करने जाएंगे तो उसकी कॉस्ट एक्स्ट्रा शैल बी पे टू द एडवोकेट and the cost will be agreed on the basis of work at the between the parties at the time when the work is there. Okay, now let's come to jurisdiction clause. Who can working hour और you'll have to क्योंकि लिख तो मैं तो खुद लिख ही सकती हूँ बट दिस इज फॉर योर प्रैक्टिस सो प्लीज कम फॉरवर्ड एंड
What are you supposed to write here?
jurisdiction clause में क्या समझाया था मैंने if you do not understand you should ask but मैंने समझा दिया है already if you have not asked so I'll obviously take it like you have understood this right so you should not ask me the question what should we write here language में obviously I can
Meaning, party two, being the advocate of a company, is not supposed to take other private matters.
no we have crossed the scope of work we are drafting now jurisdiction clause so I want you to dictate me jurisdiction clause
Okay.
and we are doing this because it's very important part of the contract if you do not understand this you should ask me it should not be the case that when I am asking you questions you are asking me what is the thing something that I've already explained you ये jurisdiction clause होता है. इसमें क्या होता है कि जब कोई डिस्प्यूट होगा, इफ यू जस्ट गो थ्रू दी लैंग्वेज ऑफ इट, कि अगर इस कॉन्ट्रैक्ट में जो भी चीज़ें लिखी हुई हैं उस बात पे कोई डिस्प्यूट आता है, कोई डिस्प्यूट अराइज होता है, तो कैसे डील किया जाएगा वो आर्बिट्रेशन एंड कंसिलिएशन एक्ट से. कैसे एक आर्बिट्रेटर अपॉइंट होगा जो दोनों मिलके डिसाइड करेंगे कौन आर्बिट्रेटर होगा. कहाँ पे होगी आर्बिट्रेशन प्रोसीडिंग्स? दिल्ली में. In case the arbitration fails, then the parties can also file a case in court of Delhi. इसको jurisdiction clause कहते हैं. मतलब कि dispute जब हुआ होगा तो कौन सी कोर्ट में cases जाएंगे, केस कैसे डिसाइड होंगे. This is what jurisdiction clause is. Please everyone take a picture. Is it clear to everyone now?
Yes, ma'am.
No, you are not required to write any contract of any section of Indian Contract Act. You just need to understand for your understanding. That is a matter in courts only. So you don't have to write uh, sections of Indian Contract Act. However, it's not barred. मतलब it's not advisable, but you can write it. लिखना नहीं चाहिए वैसे. ओके. सो इसमें हम और चीज़ों पे भी डिस्कस हो सकता है कि नोटिस पीरियड कैसा होगा. नोटिस पीरियड मतलब बिफोर whenever the services are to be ended between the parties, the notice period of 30 days is to be given to the other party. Remuneration shall be on work to work basis or on monthly basis of this amount. Duration of this contract is 1 year, subject to renew. Jurisdiction clause they've already written. Confidentiality agreement is that you should not share the ABC party will not ABC or the party two will not share any of the documents uh, uh, with the other with anyone else who are not involved in the working of the company, and will not take the work of any other similar company for the purpose of conflict of interest. Other perks and benefit, if the company is providing, then that can also be mentioned. Okay. Okay. Now let's just go through one contract. ये एक एम्प्लॉयमेंट कॉन्ट्रैक्ट है. You can have a look. We'll share this the drafts with you, but we'll share it after this after all the things I've explained. So this is only for your reading right now. ये आपको ड्राफ्ट सारे मिल जाएंगे, बाद में मिलेंगे, लेकिन you can read it for now. This contract dated day आ गया, year, कौन सी कंपनी, employee name, कहाँ, where, एंड दिस इज व्हाट इज दिस इज एन एम्प्लॉयमेंट एग्रीमेंट. तो इसको भी डिफाइन कर दिया ये क्या है. थिंग्स लाइक वेयर एज, ये आप कुछ कॉमन वर्ड्स हैं जो आप नोट कर सकते हो, ये आप अपने बार बार यूज कर सकते हो. Where the employer desires to retain the services of the employee and the employee desires to render services, these terms and conditions are set forth. In consideration of this mutual understanding, the parties agree to the following terms and conditions. Employment. The employee agree that he or she will faithfully do and best of their ability to carry out the duties and responsibilities communicated to them by the employer. Position, ये job title हो गया. All essential job and duties from time to time. May also add other duties within the reasonable scope of the employee's work. Compensation shall be paid a wage of किस हिसाब से होगा. The employee has the right to participate in any benefit plans offered by the employer. ये benefits of perks में आ जाते हैं. प्रोबेशनरी पीरियड, जब अगर प्रोबेशन होती है किसी भी इसमें, तो दैट्स आल्सो इम्पोर्टेंट दैट फर्स्ट month of the employment constitutes a probation period. During this time, if the employee is not eligible for the paid off and other benefits during this time, the employer also exercises the right to terminate the employment services at any time without advance notice. Paid time off, this is about leaves, length of time for sick leaves, personal leaves, etc. Termination, at the intention of both parties to form a long and mutually profitable relationship. However, this relationship may be terminated by either party at any time, provided 3 months' notice or 30 days' notice, written notice is delivered to the other party. Non-competition and confidentiality. As an employee, you will have access to confidential information that is property of the employer. You're not permitted to disclose this information outside the company during your time of employment with the employer. You may not engage in any work for another employer that is related to or in competition with the company. इसको नॉन कॉम्पीट क्लॉज भी कहते हैं. You will fully disclose to your employer any other employment relationship that you have, and you will be permitted to seek other employment provided that it does not detract from your ability to fulfill your duties. Now, all of these things, एक ये कॉन्ट्रैक्ट हो गया, बाकी सब मैं नहीं पढ़ रही हूँ. दिस इज अनदर कॉन्ट्रैक्ट विच, अब आप एक ये कॉन्ट्रैक्ट है, लीगल लैंग्वेज पे तो अभी हम इतना नहीं जा रहे हैं. बाकी मैंने जो बेसिक्स आई, ये बहुत ही ईजी लेवल का कॉन्ट्रैक्ट है, मतलब बहुत ही बेसिक लेवल बोलूंगी मैं, ABC काइंड ऑफ. अब आप इस वाले कॉन्ट्रैक्ट को, इफ विल कम, यू सी इसका लिखने का तरीका भी अलग है, एंड विच इज वाई आई हैव टेकन दैट आउट एंड दिस आल्सो आउट. दिस इज द फॉर्मेट दैट जनरली आई आल्सो फॉलो. ऐसे पहले ये लिखा कि कॉन्ट्रैक्ट क्या है, फिर पर्टिकुलर्स ऑफ कंपनी, और एक है नीचे आ गया, फिर 1 2 3 4 करके, इन विच ये सारी चीज़ें भी इंपॉर्टेंट है कि आप कि ये आ रहा है 1 2 3 4 एंड देन सब पैरा, बुलेट पॉइंट्स एक्सेट्रा, और ये सारी चीज़ें काफ़ी डिटेल में लिखी हुई हैं. Or any dispute arising out of this contract shall be dealt in accordance with Arbitration and Conciliation Act by appointing an arbitrator appointed by both parties as the at the cost borne by both the parties. The place of arbitration shall be Delhi, India. ये jurisdiction clause की ये वाले में भी यही लिखा हुआ है कि जब dispute कोई arise होंगे तो कहाँ से होंगे. I dash residing and holder, अब बाद में signature आ गया. Signature के साथ कंपनी के में वो भी लगती है. It's compulsorily stamped. Okay. Now let's come to agreements and deeds. I just want to ask this question: did we cover agreements and deeds in last? We did it till here only, right?
Yes.
Okay, then I think it's better that we continue tomorrow. Okay. In tomorrow's session, because there are not a lot of students who are present here. Is it okay?
Yes, ma'am.
Okay. Any other questions you have? Anyone wants to ask any question? Okay. Okay, then we'll meet tomorrow at 6 o'clock.
Bye.
Bye. Good night.
Thank you, ma'am.
Thank you. Bye bye. हो गई रिकॉर्डिंग, एक बारी चेक कर लेना.